Hi, good morning. This is Megan Applewhite back to talk about reproductive ethics. As we'll get into, this is a really big topic. There are a lot of topics, as I'll mention, that we won't cover within reproductive ethics. And my effort here is to kind of orient us toward things that you may be encountering in your day-to-day, or maybe be able to establish a good history and ethical knowledge of fundamentals that could serve you well to be able to help your patients out and the other providers that you come in contact with as much as possible. So this is an overview for the talk. We are going to talk about the rights of conscience rule. We are going to talk about infertility, assisted reproductive technology, gamete donation, and pregnant women as a scientifically complex population. And again, as I mentioned, reproductive ethics is a very big topic, and these are a few of the ones that stand out. So separating sexual activity and reproduction. Historically, sexual activity was essential to reproduction. If a woman were to become pregnant, it would be the result of a sexual encounter. But over time, introduction of assisted reproductive technologies such as therapeutic donor insemination, ovarian stimulation, ova and sperm retrieval, and in vitro fertilization, gamete intrafallopian transfer, and others, sexual encounters are now no longer essential to reproduction. Procreation is now possible for some people who were otherwise considered to be infertile. However, introducing technology into reproduction raises many ethical debates, some of which we'll get into during this talk, and as I mentioned, many of which we won't cover, but none of which are going away. And it almost doesn't matter what type of a physician you are, you're likely to encounter patients somewhere along the way that are working through reproductive health issues. Even if it is something as simple as a patient taking birth control, physicians having a sense of the history and possible ethical issues surrounding reproduction will help take best care of their patients. So as discussed in the lecture on the physician-patient relationship, physicians are expected to respect the autonomy of patients and to uphold ethical norms of the profession. However, they are moral agents in their own right who are not defined exclusively by their profession. Physicians are able to invoke conscience and not provide particular interventions, even when it means refusing to carry out the wishes of a particular patient, if it's in conflict with their deeply held beliefs, and if they feel that providing such care would go against this belief that is central to their self-identity. So this is called the conscience clause. This comes into play in reproductive ethics, and I'm going to talk a little bit about the history of it. So it began with the Church Amendment in 1973, which came out shortly after the Supreme Court's decision in Roe v. Wade. This bill was sponsored by Senator Frank Church of Idaho, so it doesn't have anything to do with the church or the Lord or Jesus. It has to do with Frank Church, a senator in Idaho, and it exempted private hospitals from receiving federal funds from any requirement to provide abortions or sterilizations when they objected on the basis of religious beliefs or moral convictions. So nearly every state enacted similar legislation to this by the end of the decade, often with the support of legislators who otherwise did support abortion rights. Supreme Court Justice Harry Blackmun, the author of the Roe v. Wade majority opinion, endorsed the clause, saying that it applied appropriate protection for individual physicians and denominational hospitals. So the rights, then in 2008, the rights of conscience rule was put forth by G.W. Bush in order to allow healthcare workers, hospitals, pharmacists, and insurance companies to decline to provide abortions or any other services that would violate, quote, a religious belief or moral conviction. Specifically, this rule denied federal funding to institutions that did not allow workers to refuse care that was against their beliefs. So critics thought that it was written so broadly that virtually anyone involved with the care of patients could refuse to provide any sort of care for any reason. This included prescription birth control pills prescribing, caring for gay men with AIDS, and performing IVF for lesbians or for single women. In this ruling, pharmacists were able to refuse to fill prescriptions for emergency contraceptive Plan B. In Chicago, this rule actually protected an ambulance driver who turned away a woman who required transportation for an abortion. So this was really thought to be a very broadly written rule. And interestingly, it was enacted at the very end of the Bush administration, so there weren't any regulations in place that really spelled out how the law would be enforced. So it was left to the Obama administration, which in 2011 narrowed the rights of conscience rule. So effectively saying that there's no indication that the federal healthcare provider conscience statutes intended that the term abortion should include contraception. The Obama administration actually asked for public comments on the topic before narrowing it down. So some wanted to keep the regs as is, and others wanted the rule to be rescinded entirely. What ended up happening after 300,000 public comments were reviewed was actually a compromise. So as I say, the original intent of the conscience law was upheld. However, it made clear that the intention of the rule was that providers would not be mandated to perform procedures that violate their deeply held beliefs, not that it would protect them from simply refusing to take care of patients who engage in behaviors that the provider simply disapproves of. So this is making a very clear distinction between very profoundly held belief versus something that they just disapprove of, sexual intercourse outside of the intention to procreate, or homosexuality. So the revisions of the rule also spelled out an enforcement mechanism that was not there in 2008 that basically set up a sort of an avenue for individuals who felt they were being asked to do things that was outside of their conscience and that really challenged their deeply held beliefs to report this this violation of their personal rights, and also to take it and it would be formally investigated by the federal government. So Nancy Berlinger is a bioethicist at the Hastings Center, and she published this paper in 2015 about conscience clauses, healthcare providers, and parents. And effectively, the take-home of the conscience clauses, as she interprets it, is that conscientious objection in healthcare cannot be framed solely as an issue of individual rights or beliefs, because it always affects someone else's health or someone else's access to care. Healthcare providers with moral objections to providing specific services have an obligation to minimize disruption in delivery of care and burdens on other providers. So you can imagine that if there is one individual physician who is refusing to prescribe birth control or to refer someone to an abortion clinic, that can really cause a bottlenecking of needs that, if medically indicated, the patient should have an avenue to otherwise access. So not only do healthcare providers have to think about how their moral objections will affect the population of people they serve, but also to think about how it could potentially affect other providers and an undue burden if in fact they can't provide care for a large group of people. So, as time goes on, we found that the average age of women at their first birth is increasing. So this is taken from the National Vital Statistics System between 2007 and 2017. And we found that there's a statistically significant increase in the age of women at the birth of their first child. It varies based on the environment where women live, but across the board, as you can see, it's increasing. And this introduces fertility problems because as people age, both women and men, there are potential complications introduced to pregnancies, which we'll cover here. So women's age is frequently scrutinized with pregnancy and with reproduction, but men is less so, although it's not without potential complication to the developing fetus. So, as women are predominantly scrutinized with regard to age and advanced maternal age being defined as greater than 35 years old, this is assuming that women are the primary caregivers. And as women age, in fact, they are less likely to be able to conceive. They're born with all of the eggs that they will ever have in their lifetime. And that number of eggs just goes down over time, as you know. And so as opposed to men, they are less likely, they are less fertile as they age. There are many genetic risks involved with advanced maternal age, including Down syndrome and other more fatal genetic abnormalities. They're also more likely to have miscarriages and stillbirths. Interestingly, advanced paternal age has been shown in studies to increase the risk of schizophrenia in the children, as well as Down syndrome, autism, and to increase the risk of fetal loss. Advancing age as it is over time with reproduction and fertility has not really been, or is becoming more and more of an issue in reproductive ethics as there are all of these complications that can arise. So what is infertility? Kind of depends on who you ask. So the World Health Organization defines it as the failure to achieve a clinical pregnancy after 12 months or more of regular unprotected sexual intercourse. The National Institutes of Health define it as the same, but also if a woman keeps on having repeated miscarriages. The U.S. National Infertility Association further defines it as 1 year of unprotected intercourse or 6 months if the woman is over age 35. Finally, the American Society of Reproductive Medicine defines infertility as the result of a disease that is an interruption, cessation, or disorder of body function, systems, or organs of the male or female reproductive tract that prevents the contraception of a child or the ability to carry a pregnancy to delivery. The duration of unprotected intercourse with failure to conceive should be about 12 months before an infertility evaluation is undertaken, unless medical history, age, or physical findings dictate earlier evaluation and treatment would be needed. What we'll see about all of these definitions across the board are that it is largely focused on a heterosexual relationship wherein for a 6 to 12 month period, you are unable to conceive a child. Now, there's only one of these definitions that points out that infertility is the result of a disease, and that'll become important in a few minutes. So assisted reproduction technology, and as defined before, is any way that technology assists individuals becoming pregnant. The most common form is in vitro fertilization. When the Federal Clinical Success Rate and Certification Act of 1992 was passed, it requires all clinics now to report ART to the CDC. And so these are the numbers sort of over the years. So this sort of follows a similar curve, if not a more dramatic curve than the increasing maternal age that we saw a few slides ago. As time has gone on between 2005 and 2017, and you can probably extrapolate to 2021 that there are more and more assisted reproduction technology cycles being administered over time, and that's probably correlated with many factors, not the least of which is increasing age at the time of the first pregnancy. So by these definitions, who is infertile? So is everyone unable to conceive a child captured in those definitions of infertile that we read? Many insurance companies base their coverage for infertility treatments and assisted reproductive technology coverage on those definitions. So individuals need to prove that they've tried or they've tried to have a child by sexual intercourse for a period of time in order to be stamped with the seal of, quote, infertility diagnosis, and then have what is frequently very costly assistance for interventions. Now, historically and societally, we focus on women when it comes to infertility. However, men and women are equally likely to be infertile. There's this second, sort of category of infertility, which is socially infertile. So gay and lesbian couples, as defined by the chart that we looked at before, they're not in those groups of what is defined as infertile, but they're unable to have a child with their current partner. So interestingly, in 2016, a lesbian couple filed a lawsuit in New Jersey because they were denied insurance coverage for fertility treatments due to the language of the New Jersey state law. So according to the suit, it required them to prove their infertility not only through a medical diagnosis, but through documentation of unprotected heterosexual intercourse. The law, that women argued in the suit, they argued that it discriminated against infertile gay couples trying to conceive because they don't fit the, quote, medical diagnosis of infertility, as they couldn't prove that the patient had unprotected sexual intercourse with a male partner for a year without successful pregnancy. And that's what the insurance company wanted them to be able to do. Finally, there's this additional category of anticipated infertility. And so there's a group of people who are prepared to become a parent, but who are single. So they don't necessarily fit those definitions either. They don't have a partner to have unprotected intercourse with for a year before it becomes unsuccessful. They wish to have a child on their own. This also applies to transgender or differences of sexual development. And finally, it also applies to people who are anticipating obstacles to a successful pregnancy, such as individuals with specific cancers or other medical conditions. And so as we can see, the definition of infertility really does have a huge role in, insurance coverage and reimbursement and sort of diagnosis of a disease. And is infertility a disease? And if it is, shouldn't it be treated like any other disease and require coverage from insurance? So looking into the general ethical issues with assisted reproduction technology, an interesting comparison of countries is who regulates it. So in the United States, there's very limited governmental oversight. So you'll see the FDA regulates human reproductive tissue. So donated reproductive tissue like eggs or sperm are regulated as human cells, tissues and cellular and tissue-based products. So any establishment that performs one or more manufacturing steps for recovery, processing, storage, labeling, packaging, or distribution of products has to register with the FDA. So that includes donor history of relevant medical records and risk factors, and the tissue donors are required to be tested for communicable diseases such as HIV, hepatitis B and C, syphilis, chlamydia, and Neisseria gonorrhea, as well as some others. So these establishments are inspected by the FDA in order to ensure compliance with reporting and testing. Now, as I mentioned earlier, the Federal Clinical Success Rate and Certification Act of 1992 mandates that clinics performing ART annually provide data for all the procedures performed to the CDC and sets forth definitions and reporting requirements. The legality of surrogacy varies by state. So state law then plays in. So you've got the FDA, you have the CDC, and you have state governments all playing a role in some type of oversight. And then ultimately, sort of the authority on this, the medical and moral authority, is the American Society for Reproductive Medicine. And they provide a lot of guidance and sort of are the place where these FDA guidelines, the CDC requirements, and the state surrogacy sort of interpretations are all put together in one place. And you compare this to the United Kingdom, where it's all one group. So it's a governmental agency that regulates fertility treatment and research. So as it is in the United States, it's very much a hodgepodge of oversight versus other countries such as the United Kingdom. So who pays for it? Right now, there are health insurance companies that frequently cite the variable and staggering costs of these fertility treatments as a reason for their reluctance to provide coverage. Insurers have also argued against considering infertility as an illness, although global health experts now do deem infertility as a disease. So insurers have claimed that fertility treatments aren't medically necessary, essentially asserting that ART is an elective procedure like a cosmetic surgery, that it's not necessary to preserve a patient's health, and so it shouldn't be required by the health insurance plans to be covered. Another frequent debate against insurance coverage for fertility treatment is that ART procedures are considered experimental, given their relatively low success rates. So according to the CDC 2017 data in the Reproductive Technology Fertility Clinic Success Rate Report, the percentages of actual egg retrievals resulting in live births were 54% for patients under 35. And it went down after that. So 41% between 35 and 37, 27% successfully retrieving eggs in ages 38 to 40, 14% for 41 to 42, and 4% for ages 43 and older. So best case scenario when a patient is under 35 years old, when frequently many women don't even know yet that they are going to have troubles, the best success is 54%. So although there have been efforts by policymakers to introduce legislation that addresses the lack of insurance coverage, no federal requirement currently mandates insurance coverage for fertility treatments. Consequently, most people end up paying for ART procedures out of pocket with little help and a lot of expense. So due to the highly controversial nature of ART and the lack of national consensus, only 16 states have enacted their own mandate to cover or mandate to offer laws. And one can imagine that this restriction on reimbursement limits the number of individuals who can afford to pay for ART, and this becomes a justice issue. So we just asked who pays for it now. Now the question comes up, who should pay for it? There's a group that argues that the individuals themselves should pay for it. ART is not medically necessary, and there are other ways to build a family, like adoption or foster families. Then there's a separate group of people that would argue insurance should pay for it. Quality of life is a reason to provide certain medical treatments, and that is utilized all the time as a reason for insurance companies to cover expenses. This same group would argue that infertility as a disease should be treated equally amongst all people who suffer from it. Therefore, they should have equal options for coverage. Finally, they may argue that genetic parenthood is a right, and it's a right not only for the wealthy, it's a right for everyone. So when individuals think of IVF and other involved costly forms of ART, the picture of what comes to mind is the wealthy, well-educated woman, right? This is the perception of what it looks like to be infertile, because these are the individuals who can afford the time and effort and expense of ART. However, the reality is the people more likely to be infertile are actually those individuals of color, those who are poor, those who have lower levels of education, and those people are within their prime childbearing years when they're found to be infertile. So it again becomes a justice issue and raises the question of if reproductive care is a human right. So the basic principles for those providing care to patients undergoing ART are to prioritize the well-being of the patient and the potential offspring. This is paramount to good care and staying focused not on the technology and not on the intervention, but actually on the patient. To be aware of information that may be misleading, advertising, investigational techniques, risks and benefits depending on the individual patient. And to recognize that psychosocial support is very frequently needed, but not frequently offered. Many interventions are costly and disproportionately available to those of means. And keeping these things in mind, if one of those providers who does offer this assisted reproductive technology is really important. So here we'll go on to gamete donation. So sperm and egg donation allows individuals who would otherwise be unable to have children to do so. But this raises ethical concerns by introducing new participants into the reproductive process. So questions, ethical questions that are raised the very, very basic way are privacy of donors and relationships among donors and the offspring. So this is an article published in 2019 in sort of a lay press website stating that there's no such thing as anonymity. With consumer DNA tests, sperm banks reconsider long-held promises to donors. So this article discusses that many clinics have actually revised, many sperm donation clinics have revised their policies not to eliminate, quote, anonymous donations, but to make clear that the term only means that the clinic themselves won't share the donor information. So others are gravitating toward open ID donor systems in which donors are told that the offspring could connect with them when they turn 18 or sooner if both parties agree to it. But what's sort of revolutionizing this, choose either anonymous or open ID, and something that's kind of the X factor that's throwing this all up in the air is the idea that there are these consumer DNA tests. So many individuals participate in 23andMe or similar test companies to learn about their family origins, and it can have unpredictable outcomes. So those who go into sperm donation anonymously can have their identities revealed in this way, totally without intending to, and it can cause serious privacy issues and family problems. People can discover that their father isn't who they thought their father was, or that they have additional brothers or sisters, and this can cause generational problems. This can cause significant issues, not only for the individual who initially was looking into finding their family history, but also for those individuals perhaps 20, 30 years ago who donated their sperm and who are now being contacted, although that's not what they signed up for. Something that goes well beyond this and is a total conversation in and of itself is the genetics of it all. So the genetic component of things, but one can imagine that it becomes extremely complicated in some situations, and it's unlikely to get simpler over time. So donor anonymity for egg donors, on the other hand, it's an issue as well, but it's less so. It's frequently done in a more open manner, with recipients having identifying information more commonly available. It is a much more involved process, and frequently, because of the how women age and become less fertile over time, is advertised in real focus to young women. So the reimbursement for egg donation is typically much higher than sperm donation, which again raises concerns for who's being targeted. So common advertisements go out to top colleges and universities to solicit donors. This one here is a Facebook ad, saying earn a minimum of $40,000 to help us complete our family. We are a loving couple in search of an egg donor who matches us and our extended family based on physical characteristics, intellectual abilities, and our cultural connection. Our ideal match would be under the age of 29, Japanese, and well-educated, Ivy League or similar. For your time and kindness, we are generously offering an above-average compensation of at least $40,000 plus expenses and possible bonus. And it's sort of advertising to this group of young women who may need the money. They're in college and they get a flyer and they think, well, 40 grand will, pay for part of my tuition, and I won't need to take out that loan. And you wonder how much coercion is sort of involved in. And it's a whole nother nest of issues. As compared to sperm donation, it pays much more. But there was a 2016 article in the New York Times that showed that the active sperm donors who participate in one of the 10 main sperm donation clinics actually have really very strict requirements. And so they are required when they sign up to participate at least once a week for between 6 months to a year. So to make that commitment, and that they would make about $1,500 a month. And it's interesting because those individuals may never know how many children they've fathered over time. And this is just another level of complexity within reproductive ethics. Finally, the last topic that we'll talk about today is pregnant women as a scientifically complex population. So pregnant women have been called scientifically complex, given the physiologic and anatomic changes that occur that can change their response to medications and infectious disease. So these are the following advances over time. In 1994, the Institute of Medicine said, no, women cannot be excluded from drug trials anymore. We need to include pregnant women in drug trials. So then in 2001, they moved not only from saying they shouldn't be excluded, but they moved from the presumption of exclusion of pregnant women to presumption of inclusion of pregnant women in human research. However, in 2012, a review of industry-sponsored trials demonstrated that 95% of trials that included women of childbearing age specifically excluded pregnant women. And in 2013 and 2016 Ebola treatment and vaccine trials, pregnant women were excluded despite known high maternal and fetal mortality rates and expert recommendation to include them. And in 2018, there was a revision to the common rule that pregnant women be removed from the list of vulnerable patients in the United States. This compromises pregnant women's autonomy if they want to participate in drug trials, if they want to participate in, specifically in vaccine trials, which has been something obviously recently that's come up. And it's interesting because this makes clear that societal values and beliefs about the autonomous choices of women in pregnancy may be at odds with the values and beliefs of the woman herself. So society and science in this way has sort of kept women from being allowed to take certain risks. Pregnancy was an exclusion criteria in 76% of the 310 COVID-19 drug trials registered at clinicaltrials.gov. Although hydroxychloroquine, HIV protease inhibitors, and vaccine trials requiring effective contraceptives, it unjustly denies women the opportunity to receive benefit from this vaccination, and it leads to harm due to the lack of evidence to inform the care of pregnant women later. So it sort of transfers the burden from the women who would consent to, the pregnant women who would consent to being enrolled in these trials, to then have no information about how pregnant women react to the vaccine, and puts it out to society at large, where there are lots of pregnant women who then know nothing about how the medication will affect them. So in summary, reproductive ethics is a very big topic, and it impacts most of the population at some point in their lives. Having a general understanding of the history and ethical aspects of reproductive care facilitates good care of patients. Conscience clause has its limitations, has changed over time, and will likely to continue to play a significant role in reproductive ethics. Ethical complexities of gamete donation are significant and increasing with commercially available genetic tests. And pushing the envelope of research to be inclusive of pregnant women is of critical importance to protect the public health. Thank you so much. I appreciate your time, and I am happy to talk about any of this ongoing if anyone has a particular interest.